Hello there. It's very good to be with you today. So you may think that as a professor of law that I would defend the courts and their role in the UK Constitution. Now I should say at the outset that I would never recommend anyone to go to court. It's expensive, it's stressful, and the outcome is never guaranteed. I'd always urge people to find other ways of resolving their disputes. But of course I do think that the courts have an important role in the system. They act as referees between the two sides. So far, you've heard lots about courts hearing public law matters, i.e. challenging decisions of the government. I want to start by reminding you that courts do so much more than that. Every day they hear hundreds of disputes involving individuals or companies suing each other for example, breach of contract. So, for example, if Tesco's has sold me a faulty kettle, I will sue Tesco's. At their best, disputes are heard by independent judges who give both sides a chance to have their say. A decision is made, which will usually favour one side, me hopefully in the kettle case, over the other, depending on the merits of the case. But the decision is reasoned and clear to help the losing party, Tesco's, understand why the judges have decided as they do. In this way, disputes are resolved in a civilised society. What about the judges? Well, their legitimacy comes from their training, their qualifications, their method of selection and their expertise. And crucially, if the government doesn't like the direction of travel taken by the courts, it can ask Parliament to legislate, either to reverse the decision or indeed to approve it if it thinks the decision is a good thing. So far, I've been talking about private disputes between me and Tesco's. And in those sorts of disputes, the government isn't directly involved. What about public disputes? Those are the disputes where, for example, a private individual or an interest group, like a trade union, challenges a decision taken by the government. Let's have a look at the following example. The government decided to introduce fees on individuals wanting to go to employment tribunals. Employment tribunals hear cases on, for example, unfair dismissal and discrimination. The fees were high and bore no relation whatsoever to the value of the claim brought. Now, these fees were introduced by secondary legislation, i.e. legislation which does not get the full scrutiny of Parliament. Remember, you've got Acts of Parliament at the top and then secondary legislation underneath. After the fees were introduced, the number of claims fell by about 80%. And evidence showed that a lot of meritorious claims were not being heard. And that meant that employers were getting away with breaking the law, a law laid down mainly by Parliament. So Unison, a trade union, sought judicial review of the rules. The Supreme Court said the rules deprived individuals of their access to justice and so were unlawful. As a result of the Supreme Court's decision, claimants don't have to pay fees anymore. Now, there is nothing to stop Parliament from reintroducing the fees by an Act of Parliament. And if there's going to be an Act of Parliament, MPs can discuss the pros and cons of having fees and at what level they should be set. What about human rights? It's one of the things that Richard talked about. I hear some of you say that the courts have gone too far in protecting rights of migrants, asylum seekers, criminals, terrorists, and therefore they've made this country less safe. Indeed, there was a well-known case where the Court of Human Rights said that the UK could not deport the most dangerous terrorist to a country where he was himself at serious risk of torture. And the judges said in that case that states are not allowed to combat international terrorism at all costs. They mustn't seek to undermine the very values they seek to protect. But I want you to think about the following things. First, the court's job is about upholding the rule of law. We're a system based on the rule of law, and that includes human rights. Second, the Human Rights Act was introduced by the government and expressly empowers the courts to apply the principles of the European Convention on Human Rights. So it was introduced by the government, approved by Parliament through usual legislative processes. Third, sometimes the courts get it wrong, which is why there's a system of appeal. Parliament can also correct what the courts have done, but there's very little evidence of the Parliament ever having used that power. Fourth, and finally, it could be you. You might not think that I'm not a terrorist and therefore I don't need to worry. But if the government decided to knock down your house to build a road, or to take away your child based on a rumour that you weren't caring for him or her properly, wouldn't you want to go to the courts to be able to protest? Thank you very much.